another motion to dismiss that was granted. This time the charges were dismissed with prejudice, which is significant. We'll go through that. So a big thanks for him for calling into the show, and then also really big thanks for sending me the documentary proof, because there's one thing that drives this radio show, and it's proof. We don't make claims that, well, I'm special, I'm a special little snowflake, and my claims are true because I say so. No, we reject logical fallacies just as much as we reject the concept of, or the actual, violent ruling class here. We don't accept that, but I do appreciate him sending me the proof. We'll show it here. Boom, there it is, dismissed with prejudice. Now, this is significant for a number of reasons, so I want to go through this because we're also going to address some of the stupid things that we hear critics say. Just the stupidest things. But keep in mind, the only reason why they are making the criticisms that they are is not because my work doesn't have merit. It damn well does. There's a mountain of evidence to prove this, and this is just the latest. They just cannot admit that there's any merit because they know it's true. They can't find any flaw in the logic. They can't find any flaw in the evidence. They don't like the ultimate conclusion that their sacred rules that they think apply to everybody don't. They just can't accept that there's no evidence to prove that. So what I want to do is I want to go through this point by point and dissect this, we'll show why this particular win is significant, and then go through some of the critics and the stupid criticisms that you can too read at marcstevens.net, because I'm going to link this in the article. It'll be to a part on my forum where you can present your evidence if you disagree, and you can see all the stupid comments, especially right here on YouTube. So we'll go through an analysis of that. Again, if you have any evidence to prove that the prosecution here, what they couldn't prove, why the judge dismissed it with prejudice, if you think you have evidence to the contrary, that you can prove that there are reciprocal obligations of allegiance and protection, that there are citizens and states and things like that, and there is a government, not just men and women forcing us to pay them, please present it at marcstevens.net or call into a live broadcast. Alright, so as he reported on the show, there was a trial. No evidence was produced to prove that just because he was physically in West Virginia that the Constitution and Code applied. Actually, it was to his wife, but it's kind of not important. There was also no witness with personal first-hand knowledge that just because she was physically in West Virginia, the Constitution and Code applied. And that is necessary because you have to have a witness with personal first-hand knowledge. If the cop is going to testify that you violated the law, he has to be able to testify and have personal knowledge that the laws apply in the first place. But they like to assume. This is an element of the charge, as we'll get to. So of course it was a sham trial. There was a judgment of guilty, so they had contacted me and they filed a motion to dismiss, well basically a motion to vacate the judgment, that they're on grounds that there was no evidence proving jurisdiction, and that's, not only that, but it's an essential element of the charge. The rules have to apply before they can be violated. So the the fact that, or the truth of the laws applying is an element of the charge. They weren't it was mal prohibitive. They weren't charged with hurting anybody. So really, it's that simple. You cannot prove that a rule is violated if you cannot prove it applies in the first place. It's just, so what I laid out here in the article, basically, this is what the argument looks like for critics who think that I'm full of crap. Because you have a standard of proof. No one's denying that the prosecution bears, a burden of proof, and the burden of proof is for the application, for the actual rule applying, even though it's an element of the charge, is always because we said so. But they think that the proof, the standard of proof that it was violated, that's beyond a reasonable doubt, or by a preponderance of evidence from competent witnesses subject to cross-examination. So you see that there's two standards here. They're both elements of the charge, but critics want to say, well, for the application of the rule, it's because we said so. Oh, but to prove it was violated, well then, you got everything. You got all your due process, protections, substantive due process, cross-examination. Come on. It's a double standard. It's a fallacious double standard, okay? So now, contrary to what the critics are going to claim, and they're going to do it even on this one, even though we have the evidence right here, they're going to deny that the motion was never granted. They'll actually write that. You can go check the comments. They'll actually write that. We know that's not true because we got a mountain of evidence to show that it's false. So not only was the motion granted after trial, it was granted with prejudice, meaning if the prosecution had met their burden of proof at trial, they wouldn't have granted the motion to dismiss because it was after the trial. All the evidence from the prosecution was already in. But we know the obvious. There is no evidence that these laws, these rules, these special rules from God or their servants apply to anybody. So being that this is with prejudice after a trial, it's what lawyers like to call res judicata. Now, they'll claim that I use superfluous and silly Latin phrases without any real meaning. Res judicata just means the thing has been decided. Res, Latin for thing, judicata for decided. So I do know that much. Few are going to claim that granting the motion, I can't even say this out loud, just because the motion was granted by the judge doesn't mean the judge agreed with the motion. That's right, because judges are routinely granting motions they don't believe have any merit. Yeah, at least not for us. Not for us. So you go ahead and laugh, but you'll see that you'll see those stupid comments and criticisms with this video, just like all the other videos. But when you make a comment like that, the important thing here is, it's one thing to turn around and say based on the evidence. But when they're saying that had nothing to do with the motion, it flies in the face of the evidence, it contradicts, of course, the evidence, and they have to speculate. Well, even though the motion was granted, it really had nothing to do with it. So if you're investigating my website, if you're looking to see if this stuff is true, you have to know, objection calls for speculation. When they turn around and the critics are saying I'm full of crap, that it had nothing to do with the motion, they're speculating. Well, what they're doing is lying. Let's call a spade a spade. They're lying. There's no merit to it at all. Baba Fangul is what we would say in my family. Some others are going to lie saying, like I said, the motion's never granted, and then they want to trivialize or marginalize, oh, it's just a traffic ticket. Just a traffic ticket. Ignoring the fact that the same issues that we're raising, the same challenge, the same elements in a traffic ticket, they have to prove in more serious charges. They ignore that part. So you can try to marginalize it all you want. You're still not criticizing me legitimately because we're raising the same issue. In a drug possession charge, which is very serious, which gets you life imprisonment in some places, they still have to prove territorial jurisdiction. It's still only a crime because a politician said so. So the laws have to apply. Oh, we don't have to prove it. There's your double standard again. They think, we just, once again, it's so stupid. We just have to prove you violated. We don't have to prove it applies. Ah, that's why Abba Fangul is really, that's the most, that's the best way to respond to something so damn stupid. Fangul, that's just ridiculous because we said so. Yes, see, the laws apply because we put you in prison. That's why I say they're criminals, because they talk like criminals and they act like criminals and they commit crimes. Hey, when people force you to pay them, that makes them a criminal. Alright, another thing that's significant about this, because it's a very common way to dismiss my work, it's of no moment, is to say, oh, they're too much trouble, they're just filing document after document after document, and we're overwhelmed. They're porcupines, I think is the way one guy did it. Really? We file a motion to dismiss, which is about 4 pages long, a discovery request that's 2, which is standard, which you should be filing a Brady request. And maybe a 3-page follow-up. Too much trouble? No, what's too much trouble is that in court, you aren't typically allowed to get away with just calling someone an idiot in order to defeat the argument. Or trying to claim, I don't have to prove that. I don't have to prove an element of the charge. Because typically that's bad PR. This holds no water ever, but even more so here because this was after the trial. After the trial! Where is there too much trouble to respond to a 3-page motion? Why even read it? Most of the time they don't. They have an administrative assistant. Traffic court, I doubt they ever read the damn motions. Just denied, denied, denied. All they had to do, the judge, like they do so many other times, tell the clerk, yeah, just rubber stamp this one denied. It came from Marc Stevens. Yeah, denied. Ah, come on, too much trouble? Ah, Funkel, no. It's not holding any water. It's after the trial. It's already been done. One rubber stamp, well, denied, no explanation. This I had to do, because it is so stupid. I want to address this again here because there's some critics, even though there's undeniable evidence, just like this, right? It is dismissed with prejudice after trial. They'll turn around and say, it's just a traffic ticket. It will never work on anything more serious. I swear to... Not true. MarcStevens.net, we have drug charges thrown out. We have many, many, many tax assessments thrown out. So I would say an IRS attack is a hell of a lot worse, a hell of a lot more serious and more difficult to get thrown out than a parking ticket or a traffic ticket. So, yeah. So all these false claims against me, they're all proven false. I've addressed each one. All they do is to detract your attention. And anyone honestly investigating this is to detract to take your attention away from the fact that they have no evidence to prove that their sacred rules actually apply to us just because we're physically in Canada. And I'll do another video where the Rational Wiki, somebody actually accused me of making a circular argument by asking for evidence to support someone else's claim. And that those making the claim, it applies because it says so. That's not circular. But my pointing it out is... Yes, the stupidity that the critics of my work have to stoop to because the evidence is right here. The evidence is right here. So anything that they can say and do to distract your attention and get you even more afraid. Don't listen to Marc Stevens. He's full of crap. He's never had a ticket thrown out, even when the motion's granted. Trust me. I'm on YouTube. Trust me. It's not because the judge agreed. Oh, Funkel, I swear it's so stupid. Why should you even have to respond to this trash? And I'm not saying critics should be ignored, because I certainly don't ban them. There's proof enough on my website and here on YouTube, unless they're spamming, which is different. It's not a criticism. I'm not afraid of criticism, but like I said on the last broadcast, get it right. If you're going to criticize me, get it right. I may be an idiot, but address the argument. Don't just level an insult or an ad hominem. Address the actual argument. Show where my facts are wrong and show where my logic is wrong. You can't do that. All I want is for people to have the opportunity to look at the actual evidence. Don't look at the rhetoric. Look at the proof that's actually there. Listen to the call of shames. Watch some of the interviews that I've done. I interviewed the Chief Justice of, well, I didn't interview, I confronted Scott Bales, the Chief Justice of the Arizona Supreme Court. The best he could do is say, well, proof that our laws apply to you, dirtbag, is we put all these other people in prison. No. It's not proof. It's not proof. Look at what the evidence tells you. What I presented in this video is just one more example of the evidence that the motion has not only been granted, it's been granted after a trial and with prejudice numerous times. That's res judicata. So if you honestly look at the evidence, which is real brief to summarize, it was granted with prejudice after the trial, so without speculation like you critics have to do, the judge agreed that the prosecution failed to meet their burden of proof, and he granted it. It's not causing too much trouble. It's not because the judge is angry at the prosecution. It's because the prosecution failed to meet their burden of proof. End of discussion. And that's what the evidence tells us, that's what the data tells us, that is what we're doing without assumptions. The critics have to use assumptions and ad hominems. But if you disagree, like I said so many times before, present your evidence. Not excuses, not logical fallacies, not further argument. Provide actual proof that a written instrument from 1787 actually applies to me today just because I'm physically in Arizona or any other part of North America called the United States. Show your evidence. You have to have proof of reciprocal obligations, of allegiance and protection, because that's what makes somebody a citizen. Not because I said so, because that's the law. And I'm only citing the law to show the inconsistencies, not because I believe in it. Oh, if the laws don't apply, why do you cite them? To show a flaw in an argument. That's what I'm doing here. To show a flaw, an obvious flaw in the argument. To have states and citizens and have a government, and not just a group of men and women forcing us to pay them, you have to have a state, and a state is made of citizens. As I said 1,000 times before, to be a citizen means you have to have membership in a body politic, owing a duty of allegiance in return for a duty of protection. These are reciprocal obligations. That is not my opinion. That's the Supreme Court saying what a citizen is. It's not just being born here. It's not just being naturalized, because to be naturalized, you got to swear, you got to put your hand to the oath. You have to take an oath of allegiance. If you have that proof, and not just saying that Marc Stevens, I'm an idiot, or I'm full of crap, BS alert. I've laid out all the facts, I've laid out the argument, I've laid out the logic leading to the conclusion. If there's a flaw anywhere in there, then present it. I love to hear it. We're going to have a separate thread on the forum at marcstevens.net for this video and additional videos, so that you can present your evidence there if you don't want to call into a live broadcast. But I'm talking evidence. Saying the laws apply because they say so is not evidence. Saying that the people agreed to be ruled, no, you pay or you go to jail. That's not proof of allegiance and protection. You don't get a duty, create a duty of protection by threatening to shoot somebody if they don't pay you. That's why critics, even career prosecutors, will not address the issue of allegiance and protection, because they know damn well there's not a single fact to support their claim that they're citizens. Not a single fact. Because the evidence is dead set against them. Because they're just men and women forcing us to pay them. But hey, if you can do what the prosecutor in this case couldn't do, and what the judge couldn't do after a trial, point to the evidence, if you think you can do that, we're live 4 hours a week. One on Saturday from 4 to 7 Eastern Standard Time, and Wednesday nights, live video stream. So present your evidence. Again, my name is Marc Stevens. The website is marcstevens.net. I really look forward to hearing from those critics who have actual evidence.